Can a person who is being prosecuted for BP22 be a defendant in a civil case for the same action, for the same cause of action? This is a case of Edmond who issued a check for 300,000 pesos and paid it to LV. However, such check for 300,000 pesos bounced. Thus, in 1997, LV filed a case against Edmond for BP22 for the bouncing checks. 3 years thereafter, LV filed another case against Edmond for recovery of sum of money. In that same civil complaint, she also prayed for preliminary attachment in order to secure recovery of the amount stated in the check that has bounced. Edmond's question is, can a separate civil action be filed against him for the same cause of action, for the same amount of money? Will this not be litispendentia? There is no independent civil action to recover the civil liability arising for an issuance of an unfunded check prohibited and published under Batas Pambansa Bilang 22. Rule 111 Section 1B of the Rules of Court states that the criminal action for violation of Batas Pambansa Bilang 22 shall be deemed to include the corresponding civil action. No reservation to file such civil action separately shall be allowed. Supreme Court Circular 57-97 that took effect on November 1, 1997 states, the criminal action for violation of Batas Pambansa Bilang 22 shall be deemed to necessarily include the corresponding civil action, and no reservation to file such civil action separately shall be allowed or recognized. To repeat, LV's separate civil action to recover the amount of the check involved in the prosecution of the violation of BP22 could not be independently maintained under both Supreme Court Circular 5797 and the coded provision of Rule 111 of the Rules of Court, notwithstanding the allegations of fraud and deceit. Regarding Edmond's question whether LV's action to file the second case was proper, the answer is no, as it involves litispendentia. For litispendentia to be successfully invoked as a bar to an action, the concurrence of the following requisites must be present. Namely, there must be identity of parties, or at least such as to represent the same interest in both actions. Second, there must be identity of rights asserted and reliefs prayed for, and the reliefs are being founded on the same facts. And third, the identity in the two cases should be such that the judgment that may be rendered in one would, regardless of which party is successful, amount to res judicata in respect to the other. If you have any questions regarding your legal concerns that are not yet pending before the courts, please do not hesitate to email us at ptv4newscenter@gmail.com. This is Attorney J.J. Jimeno Atienza for the Rule of Law.